We're live.
Welcome everybody to House Energy and Digital Infrastructure. Today is Tuesday, February 23rd, and we are. What did I say?
23rd.
Yeah, I was going to screw that up.
23rd.
Well, it's 2-3.
That's right, man.
Oh, May 20. Yeah. Wishful thinking. All right. It's Tuesday, February 3rd. We are here to walk through our latest draft of H527. I'm Rep. Kathleen James from Manchester.
That's Scott Cabell from St. Johnsbury.
Richard Bailey, Memorial 2.
Chris Morrow, Wyndham, Windsor, Bennington.
Michael, Southwest Caledonia 2.
Christopher Howland, Rutland 4.
Dara Torrey, Washington 2.
Graham Klubner, Chittenden 13, Burlington.
Laura Civilian, Wyndham 2.
All right, and in the room.
Dana Weed Perry with the Crossing Group.
Great.
And
Andrew?
we have one other guest who is so immersed in his phone.
Sorry, Chris Price here from MMR listening for Verizon.
Great, thank you. All right, for the record.
Ellen Tchaikovsky, Office of Legislative Counsel. I'm here on the committee's amendment to H527. It is draft 3.2. It is the first draft that you are seeing. Since I was last here, I had a number of conversations with the chair about what exactly direction the committee wanted to go. So there were some internal drafts, which is why this is 3.2. So the first section one, this is a strike all amendment, but the first section 1, is what is currently in H527 as introduced. It is a pushback of the sunset on section 248A until July 1, 2029. It's been pretty standard in the life of 248A for there to be 3-year sunsets. And so that is what you are going with here. Section 2, though, is new and is based on the testimony you have received. And so it's a session law provision directing the PUC to work with stakeholders. So page 1, section 2, Public Utility Commission recommendations, increased participation. The Public Utility Commission shall recommend changes to 30 VSA section 248A to increase transparency, efficiency, fairness, and the ability of individuals and municipalities to participate in the telecommunications siting process. The Commission shall hold at least 2 workshops on the issue and shall invite, at a minimum, the following: the telecommunications service providers that have used the Section 248 process. On to page 2, the Vermont League of Cities and Towns, Vermonters for a Clean Environment, the Department of Public Service, the Department of Public Safety, the Agency of Natural Resources, and any other relevant stakeholders. So this is the minimum of who they shall invite. Typically, when the PUC does workshops, they are open to the public, and any member of the public interested can attend or participate, but these are the people that are being specifically invited if they would like to attend and participate on the issues. Section B, subsection B on page 2, line 5. This is the list of things to be discussed in the workshops. And this is based on the recommendation that Will Dodge provided. So the workshop, although that should probably say workshops, shall address the following topics and procedures: the advance notice process, including the content of the notice, distribution requirements, pre-petition hearings, and site visits at the municipal or regional planning level, pre-petition supplements and amendments, recommendations from municipal entities and regional planning commissions, and the effect of failure to file a petition within 180 days following the advance notice date. Subdivision 2, petition submission requirement based on project categories, including towers, power replacements and extensions, small cell facilities on utility poles, new antenna co-locations, and eligible facility requests, and de minimis modification site visits. Subdivision 3, procedures for the post-petition comment period, including consideration of comments, motion to intervene, and requests for hearings, as well as for issuing a significant issue determination during the review period pursuant to 30 VSA 248A-F. On to page 3, subdivision 4, procedures for contested case proceedings following a commission's significant issue determination that include scheduling, site visits, including visibility determinations, discovery, and motions. Subdivision 5, conduct of evidentiary hearings, including allowing for public participation and streamlining the post-hearing briefing process to comply with the applicable review periods under 248A-F. Evidentiary burdens for section 248A criteria, including rebuttable presumptions of compliance from agency determinations, requirements for supplements and amendments to a pending petition with express standards for substantial and non-substantial changes, streamlined administrative process for transfers of certificates of public good issued under section 248A in whole or in part, and any other topics the commission determined should be addressed through rules or orders following consultation with stakeholders.
Why don't we, let's stop there. Go ahead.
Well, just because the actual direction is in the last paragraph. So this is the end. So on or before December 15, 2026, the commission shall submit an overview of the process it conducted, the recommendations it has, and a description of any changes the commission made to the section 248 process after consultation with the stakeholders. And they shall submit that to this committee and Senate Natural Resources. So this is not asking for a full report. It's asking for them to hold at least 2 workshops, look at all of the items on this list, and report back to the legislature if they have recommended changes, which may be statutory, and if they took any, made any changes after the consultation process, because they do have the ability to amend their order. And so maybe they take action immediately after the workshop. This is roughly based on the process you asked them to do last year about the definition of plant, having them have a workshop, meet with the stakeholders, and provide recommendation back to the legislature. I will just point out, though, you're giving them roughly 6 or 7 months, and this is a significantly longer list than looking at the definition, a singular definition. So that this may be a lot to do in 2 workshops. Okay.
Rex Sibelia?
Thank you. Maybe we could do it in one.
Sure.
Sure.
I mean,
so I will just say that what I've heard is that really no one is, especially, thinks the process is perfect. The PUC has said that the ongoing sunsets prevents them from wanting to take up rules or suggest any statutory changes. We've heard from towns and citizens that they feel like public process is not going as they would like. And we've heard from some of the providers that they also would like to see some changes. So, this feels to me like a pretty reasonable path forward. No one is, I don't know that we've hit everything that each one of those entities wants. It'll be interesting to see the Senate's disposition to this, since they have started from remove the sunset as their starting place. So this feels pretty reasonable to me. And actually like possible to improve the situation. So, thanks.
Just real quick. We've had some folks come in since we all did introductions. Could our newest guests introduce themselves, please?
Yep, Allison Descathy from Monitors for a Clean Environment.
Claire Buckley in the Public Affairs for CTIA.
Okay,
Nick Sherman, AT&T.
Greg Taylor with PUC.
great, thank you. I had a,
Yeah, just and one more thing, Madam Chair.
Yeah.
So, you know, I would not say that this list is based entirely on AT&T. I think this list is compiled from what we heard from both the folks that Vermonters for a Clean Environment has been representing and AT&T. So we may not have gotten it right, but I wouldn't say that it's exclusive to one side or the other.
let's see, I've got a couple comments and some questions. Why don't we do my questions first? I wanted to ask about we had I know a couple specific questions that other committee members want to raise, so I don't want to get into their questions, but I did want to kind of hone in on, and I'm not sure if this is the right place in the draft to discuss these ideas, but I wanted to hone in on page 3, line 7, it's subsection 6 or subsection 6. Can you talk a little bit more about what that means? Evidentiary burdens for section 248A criteria. What does that mean exactly?
So, when an applicant submits their application under subsection C of 248A, there's a list of criteria that they have to make a showing in regards to. So some of the Act 250 criteria are on that list, as well as references to outstanding water resources. So they have to demonstrate that their facility is not going to have an undue adverse effect on a number of different things. And so I think this is asking, what level of evidence do they actually need to supply to demonstrate that they have met that burden? This has been going on for 20-ish years, so there are already procedures in place that the PUC uses, but I guess it's asking if rebuttable presumptions should be included. This is something, I think I don't know if this came up in your testimony, I haven't watched all of it, but under Act 250, there is often a discussion of whether a permit from one of the state agencies, like Agency of Natural Resources, if they issue a permit related to wetlands or stormwater, if that is a presumption that they have complied with this other citing statute 248A. So whether or not the PUC should adopt that posture, that an agency determination is comes with a rebuttable presumption. The opposite of that would be an irrebuttable presumption, which is a stronger weight, the evidence. I don't know. I don't know right now about the evidentiary burdens that they use, so you may want to hear from the PUC how that works, but it's about the weight they give the evidence that the applicant has provided as part of their application.
The reason I asked is that one of the things that came up for me a lot in testimony, or that I was thinking a lot when we were hearing testimony, was that somewhere in there, I know that the PUC, needs to consider weigh the public good or public benefit. And I'm curious about how that's defined and the difference between a cell tower that's going to bring coverage to folks in a rural area and more like a spec tower that's going to be a B2B two-way radio tower for UPS. So to my mind, those are not both in the public, they don't reach the same criteria of public good. So is that a definition we asked them to look at, or is that already in here somewhere?
So there isn't a specific. Okay, so the permit that the PUC issues for a number of different things, electric facilities, telecom facilities, the operation of a utility is a certificate of public good. To issue it, the PUC looks at if whatever blank is will be in the public good. For 248A, the only specifics surrounding that definition is in 248A. Plus, they also take into consideration the criteria in subsection C. But in 248A, it says that the applicant can obtain a certificate of public good, which the commission may grant if it finds that the facilities will promote the general good of the state, consistent with section 202CV of this title. And so that is the intent section related to telecommunications facilities generally in Title 30. I don't have that language in front of me. I can get it off the shelf if you'd like to hear it, but it's a list of things that were put into statute that the legislature had as the intention for telecommunications in the state. I don't know if there's any case law interpreting this. Honestly, I haven't looked into that specific question before, but the PUC is ultimately looking at if an applicant, if what they're proposing will promote the general good of the state, consistent with how the state has identified its intent for telecommunications facilities, including consideration of the criteria listed in C. I think that's as best as I can do right now as an answer. The PUC may be able to give you more context, but I haven't looked to see if there's any specific case law interpreting it or I have started to, but I don't have a deep knowledge on if it's been interpreted more specifically than that for 248A. Okay. Merle?
Did you
Oh,
not
sorry.
something?
That's all right. Well,
Okay.
you go ahead.
I
do have a question. but-
basically the same question as the chair, except with substantial deference. It came up a few times in testimony that some of the towns had things in their town plans, but maybe there was some confusion, at least confusion in my mind about when substantial deference was actually deference and when it wasn't. But I just want to make sure in this review that is that in here in the review of the workshop somewhere? I just think that that's like something that just needs to be brought up in the workshop as to clarify so that towns can have clarity on what that really means in practice.
So there is a definition in 248A of substantial deference and where it's used in 248A. And off the top of my head, I don't know if it's in this draft.
But I'd like to
So
just bring it up as committee's consideration. I think that might want to get in here somehow.
Yeah, I had a sort of a specific question like that. One of the things that we've talked about is the importance of having a public service department at the hearings at the municipal level. And so I'm wondering if we should include that as something to look at. So that would be under B1. I would suppose.
Yeah.
And in that list, I'm supposing that perhaps on line 8, where it says, line 7 says pre-petition hearings and site visits at the municipal or regional planning level. And maybe including whether participation by public service as such hearing should be required, something like that.
So the statute does say that the department shall attend the public hearing.
Oh, it does. Oh, it does.
Yes, it
Okay.
does.
I was under the impression that it was at the municipality's request. So
Well,
then maybe I'm wrong. It does.
I thought the hearing was at the municipality's request.
no, so the municipality can hold a public hearing if they so choose, and then the department shall attend at the request of the municipality. So the municipality has to invite them.
Oh, yeah. Well, so if the public service attended it, then they would be, if they were required to attend, then they would be in a better position to take the municipality's recommendations into account when they're at the VUC CPG hearing to determine whether to grant a CPG.
So are you saying that the municipality shouldn't have to invite them, they should come automatically?
In effect, yes.
Okay,
Well, the question is, should this workshop assess that question?
okay.
And sorry, just remind me, since I think I got that wrong, and I can certainly look at our notes. The municipal hearing is mandatory.
The municipality has the option to hold the public hearing if they want.
Okay, well, that's what I meant. So I wasn't wrong. The municipality has the option to hold a public hearing. It's not.
Yeah.
But then if they do hold a public hearing, they have the option of inviting public service.
Right.
So I guess my question is, if they do hold a hearing, should public service be required to attend? Even possible.
I feel like we're saying the same. I feel like that's what, okay, I think that's a very narrow distinction of what's already required.
It's a narrow distinction.
Because how else would DPS know that they weren't invited? If they're invited, they have to attend.
Well, but I think the statute now says the municipality can invite public service if they want to. I
Yeah,
don't know exactly what the words are, but that's the point, right?
but, and so you want the municipality to have them there.
Well,
Okay.
I'm wondering whether that should be the case. I'm wondering whether part of this workshop should be to assess that.
Okay.
Who was next?
Well,
Oh, sorry, Repertory, and then
Just a follow on to Rep Campbell, we did hear enough testimony to show us that the educational materials that the department has are not being used. And that makes me wonder if there's a contact point missing. So I like the idea of ensuring them.
Yeah.
And then I just wondered, on line 2 on page 2, if we should spell out the regional planning commissions, since they have a role as well as municipalities.
Yeah, they get notice.
what line was that again? Yeah.
Maybe after League of Cities and Towns.
That line number would be
2.
line 2.
Page 2 on 2. And then one other question is just, do you feel in B on that page? With the advanced notice process, would the length of time come up as well in the workshop? Like, is 60 days adequate? We were hearing that towns don't feel like they have enough time to get all the information and get the public hearing and all of that within the window. So I feel like that could be part of the discussion. Did anyone else?
Isn't
wonder?
that listed? B1, line 6,
Content.
the advance notice process.
timeline.
Timeline, yeah, I just thought maybe spelling out the word. Timeline,
Who was next? Yeah, Rep Suffer.
Couple of questions. So, always done that. On page 3, number 4, and it says the contested cases. It includes the terminology, including visibility determinations. Is that a balloon test?
I don't know.
So Is there a way that a balloon test can be required for each application?
Yes, yeah, I think you can specify, and this, I mean, this list is about things the PUC should look at to then have recommendations back. I think if you wanted it to be required, you would potentially need to amend the statute, which this isn't doing specifically, this is asking them to look at it, so, I do think, I don't know, I think visibility determination, I don't know if balloon tests are part of that, they might be, so you can be more specific there if you'd like to.
So I was going to try to answer that. Just looking at what was submitted by Mr. Dodd. You can comment I think
Yeah, I did see that.
you saw that?
Yeah,
Okay.
yeah.
So I think the idea was that it could be a balloon test, it could be a crane, it could be something.
Right.
Yeah.
Okay, and kind of like to see that worked into that wording somehow on the balloon test. So the other that I come up with has been brought up here, substantial deference. Is that only for contested cases? Or is it something that a municipality and abutting landowners can automatically have that? Or is that not the use of substantial deference?
So right now in the statute, substantial deference is defined as the plans and recommendations in C2 are presumed correct, valid, and reasonable. And C2 currently says the substantial deference has been given to the plans of the affected municipality. And so I think it is just the municipality that gets substantial deference based on their plans, not abutting landowners.
Even before it be deemed a contested case.
Yes, this is part of the initial showing the applicant has, is if they're, if the application has given substantial deference to the municipality's plan.
Okay, so in other words, in order to add any abutting landowners, we would have to modify statute.
Mhm.
Thank you.
I believe so. Yes, I don't have the statute. I think so. I'll reread if any.
Okay, thank you.
I don't know who's first here.
Who am I fighting against?
Sorry. No, quick.
Well,
Please.
I'm just wondering, because it says municipal plans, does that imply zoning bylaws?
So it does go on to say that nothing shall prevent a municipal body from basing its recommendation to which substantial deference is required on an ordinance or bylaw. Yeah, so that paragraph actually goes on further too, so there is more about that. Yeah.
A couple of things. I would like to suggest that we add to the list of things that we ask the PUC to talk about, is whether there should be some default standards that they can fall back on for the municipalities that do not have zoning, of which there are a great number. For instance, if town zoning plan requires whatever 300-foot setbacks for cell towers, then great. But if towns don't have a requirement, should there be such default requirements for all the towns that don't have zoning?
Can I just jump in with a question to make sure I'm hearing what you're saying?
Yes.
So what you're saying is asking the PUC to include as part of their workshop, a question about should there be, for towns that don't have zoning, some other set of standards?
Yes,
Should there be some other set of standards?
indeed.
Okay, so that seems.
So I will say that, so roughly 55% of towns have zoning, but somewhere between 80 and 90% now have town plans. And so I think there's moving in the direction of almost all towns trying to have town plans, which is a way for the town, I think, to establish at least some basic telecommunications plans as part of that plan, instead of going through the process of adopting a whole zoning bylaw or ordinance. So the universe is smaller than just towns that have full zoning.
Yes, I'm just not sure the town plans include things sort of specifically about cell tower sightings, and some towns have never faced it. And, I mean, the things, setbacks, maximum height, illumination, working hours, that trucks can go up and down the access road, like there's all that stuff that a town plan may not include at all. And I think it would be good to have a set of standards, which we follow in the case that a town has neither zoning nor specific rules in the town plan relative to those issues.
I don't want to interrupt you.
No, I think conceptually, the rest of the findings provision in 248A are that there's a state standard that attempts to consider a number of criteria. And if the towns have input, that's one of the criteria, if the town has a plan related to that. So it seems like that's the option for the towns that want to say something, to say something is in the planning process. And if they don't, there's already this sort of state process to evaluate. So it seems like it would already be covered, because it seems like it would already be covered to me conceptually, but
Another
you can add that.
thought, well, I was just gonna say, we need to remember too, the list of stakeholders that we're considering requiring to participate in this workshop, which includes the League of Cities and Towns, and did we talk about adding an RPC voice? So,
Hiring the RBCs.
That would be good.
It's about they're invited. If the individual group doesn't want to participate, they don't have to.
right, so invite, but I would assume the league would want to be there and would want to speak for the municipalities, and I would tend to rely on them to bring the voice of what's best for the towns. And that expertise, like these many have zoning, these many already have a plan. We're missing 5% of
Could
them.
we rewind just a sec? Explain to me how this would work. If a tower company wants to site a tower in a town that doesn't have zoning and whose town plan does not speak to all those things I've mentioned, how would we then ensure that the tower doesn't end up too close to a school or something like that?
So that is a specific example, too close to a school. I was thinking, if the town hasn't done any planning on this subject, how can you know what the town's feeling is? And so without that, there is this list of criteria that the PUC itself has to go through, because the legislature has directed them to go through and evaluate if the tower meets what these state standards are. So if the town hasn't done any planning and had a discussion, there isn't a way to know what that town feels. And so having a default that isn't actually specific to that town it feels odd that would just be generic, where we already have the sort of list of other things that the PUC has to be reviewing anyway, and it would potentially overlap.
I'm concerned that a small town, I would like to give them some legal protection against a tower getting sited where they don't want it. And if we're giving deference to zoning and town plans and they have it, then they have that protection. But if they don't have those things, then, all they can do is argue. And we have heard that they often lose those arguments in front of the PUC. They lose those arguments in the Supreme Court. So I would like to see it. I would like the PUC to have a conversation as they're formulating this to see if the good people in municipalities of Vermont would find that help.
Do we have more?
I could just read, getting back to the public good
Yeah,
comment. In the criteria, there is provide for high quality, reliable telecommunication services for Vermont businesses and residents, and provide the benefits of future advances in telecommunications technologies to Vermont residents and businesses. So I think that's where the two-way tower comes in. That's very broad, public good definition. There's a number of criteria, but they're all pretty broad, which might be fine. I'm just.
so,
You're suggesting that pretty clearly suggests that two-way radio for a private company is a public good,
Certainly could be interpreted that way.
and apparently has been.
Yeah.
So that would require a change to that statute if we wanted to narrow that definition.
okay, so, I guess just to, step up to the people have more specific questions on the language, because I want to talk about what I think we're trying to do here. Okay, so, one thing is just, I said this to a couple folks earlier, but as as the person who's, regrettably in charge of time management, for our committee, I feel like we have taken really extensive testimony, and I feel like we've heard from a really wide range of folks. We've heard from cell providers, we've heard from the PUC, we've heard from the department, we've heard from municipalities, we've heard from the league, we've heard from a lot of concerned Vermonters. And so I feel like we've taken some in-depth testimony, and I do feel like it's time to get the bill out of here. I think it's time to vote it out and move it along to its next step, especially because, as we know, at least the legislation we've seen on the Senate side is coming from a very different point of view. So I would like to get this bill out of here, get it to the floor, get it over to the Senate. This could be the kind of bill that winds up in conference. I don't know. But I want to make sure that we move it with plenty of time for everybody to kind of give it its due consideration. So the balance I think that we're trying to strike, and the reason I like this approach is that one, we're not letting it sunset. So we're not just punting and shutting down 248A and letting everything revert to Act 250. We're also not just kind of blindly extending or eliminating the sunset. I think we're trying to acknowledge that people have a lot of concerns with the way the process is working. It would be extremely time consuming and require a significant amount of additional testimony for us to try to rewrite the 248A statute to what we think is a perfect product. That is not a quick process. I also think that it would be time consuming and complicated, and I'm not sure about transparency and outcomes. just in terms of public participation, if we just order the PUC to rewrite the rules. So I feel really comfortable with the balance we're trying to strike here, which is to say we've heard a lot of conflicting testimony. This is not working, and to adopt a process that we successfully used last year when we were having a hard time finding that balance. We asked the PUC to do a workshop. We gave them a specific task, and we asked them to come back to us with a report, or with recommendations or with actions. So I think we're keeping this on the balance beam. I think we've made a lot of progress. I think a lot of folks have been heard. And so the bill that we vote out of here, I hope, stays on that balance beam and keeps this firmly in the section of PUC workshop. And I think we provided them with pretty robust instructions. My concern is actually, this is a lot of work. We asked them to consider the definition of plant. This is a significant task. And we're asking for 2 workshops, which the point of that, of course, was to try to make sure that everybody has a chance to be heard. So I think we had a couple of specific requests today for some revisions that sounded easier. I think we wanted to see about asking the PUC to invite the RPCs. I think we wanted to have them think about whether DPS should be required to attend the public hearing if a municipality requests that public hearing. I have wondered at times about whether a municipality should hold a public hearing, period. But whether that should be required, but I'm not sure certainly we're not going to ask that for all the many de minimis applications. So, but I have wondered whether should it just be on contested cases that the municipality is required to have a public hearing and DPS is required to attend. I don't know what language could get to that as something that they could consider, whether that would be an improvement. I think I heard on page 3 that visibility determinations is maybe okay because that's intended to cover not just balloon tests, but maybe some other way of seeing what it would look like a crane test. Rep. Southworth, is that working for you?
I think you were gonna look about actually specific language.
Okay, I couldn't remember where we left that.
Okay. Yes, I will. Well, I didn't know if Representative Campbell answered it.
He did, but
Oh.
it just, to me, it's not in here. It's just the wording that we saw from Mr. Dodge showed specifically those words. This doesn't. So I just want to make sure that we have balloon test in there. I mean,
You want balloon test specifically?
I think so. Yeah. I think it's an important piece, that whole application process.
And then,
Or could you say visibility demonstrations such as balloon tests or something like that? Would that be adequate?
I'll leave that to the
Okay.
lawyer.
Yeah. Yeah.
and then I heard somewhere a desire to explore substantial deference and the public good. And I don't know what to do with those 2 things, but they seem important to a lot of us.
I think public good, I think of a whole can of worms in the statute.
They're both really broad things.
Doing,
Yeah.
I don't know, we could,
Uh,
I mean, it'd be nice, but I think we could
So,
get that in.
I mean, essentially, essentially, the PUC will come back in December with, we'll learn everything that happened. We'll see what recommendations it has. They may have, changed the process, and maybe that would be the time to consider that broader. I mean, if the entire intent of all of our telecom statute is defined in a certain way, that is foundational, and I don't want to pull away the Jenga thing that collapses all of our telecom laws. So I'll let that one go. I don't know if we've figured out the substantial difference.
That covers both of that.
Well, I think the question was if substantial deference should be given to adjoining neighbors.
Yeah.
Was the question. To be
PUC would
considered.
contemplate.
Yeah.
What if they don't agree?
Yeah, that would be a hard one.
If you could have 6 abutters and 4 want it and 2 don't or something.
I mean, that's the whole process they go through now, right?
But
The key point is that their concerns are
heard.
right? Substantial deference only works because the towns actually have it in their plan or in their zoning. And you have something concrete to defer to, right? Opposed to someone's opinion, except we run into the your issue of towns that don't have any.
And the league will hopefully speak for those folks.
Yeah.
Rep. Civilian?
Yeah, I just want to make sure before we lose Ellen, that we ask Ellen if she is clear on what we're asking for and if she has any questions that are open about this.
No, the chair was running through the list I had made. And I think that the last of my list was just substantial deference. If you wanted to add that somewhere in here for them to consider. And then also the part about town planning, town without planning.
Substantial? How would you recommend?
It's something along the lines of consider whether substantial deference should be given to any other parties, like adjoining neighbors.
Well,
But I do think it.
if I remember correctly,
Yeah.
like there were some towns that were clearly against some siting and were not given substantial deference.
Yes.
That's where I get hung up. So what? I don't understand. If you're giving them deference, I mean, if it's in statute, you're giving them deference, then that conflict needs to be explored a little bit in this workshop. Like, what does that mean, substantial deference, if you're not automatically accommodating the language in their town plan or their bylaw or their, zoning laws?
Okay, so that was a separate piece you wanted to discuss too,
Well, that,
or
yeah, that was the main reason I brought up substantial deference.
Okay.
Not to necessarily
Okay.
expand it.
Oh, okay.
Some, I think, Representative Southbridge brought that up, but and people on board with this, because like,
Well,
I don't want to confuse it.
I'm on board with one, I feel comfortable with the fact that the league is going to be there and that they're going to show up and that they're going to speak for towns. So that's a baseline okayness for me, just right there.
All right, that's fine.
I
Just leave it at that.
Can I ask?
Mhm.
I think what is unclear is under what circumstances can the PUC decide to ignore a town plan? Right, and those circumstances, as far as I know, those circumstances are not defined, or are you about to find the definition?
I was gonna say that the substantial deference language was added more recently. I think after some of these situations came up where towns felt like they weren't being heard.
But is substantial deference a well-defined, commonly used term in these cases?
It is in general law, I would say, but it has a specific definition here that's been added to 248A. It's that if the town's plan is considered correct, valid, and reasonable.
And that means, as far as I recall, as long as the town plan isn't written so as to ban towers by saying, they can be no more than 6 inches by 6 inches on their footprint or something, something obviously exclusionary.
Yes, there's additional language that says unless there's good cause for the plan to not be given substantial deference, which that would be an example of.
Could we just add a new item? Should we add something asking them to just take a look at how municipalities are granted, how and when, I don't know.
Something like, yeah, it'd be good. Yeah.
So that was the list I heard. I know that I believe that the, cell providers, CTIA, are taking a look at this draft and are going to provide us with some written testimony, about how they feel about the draft, the language.
Would you like me to speak?
Yeah.
Okay. I think we reviewed it, and of course we'd like a longer sunset, but at this point, you know, we understand the committee's in a rush and wants to move it, so we're not going to submit any written testimony.
Okay,
But thank you.
sure. And just to clarify, we're not in a rush. I just feel like we spent a lot of time creating a thoughtful solution.
Mhm.
And I know that we'll want to hear from the PUC. So we can send the draft to them, or, Greg, what,
I can find the draft.
do you guys want to submit written testimony? Do you want us to find time for you to come in?
Yeah, if you want.
Okay.
Whatever you want.
Great. All right. So I think those are our next steps. So maybe, so I guess we're not expecting written testimony. We'll, Greg, we'll get you on the schedule ASAP,
Sure.
and then we'll schedule a vote, and folks can let us know how they feel. Okay. Thanks, everybody. Oh, Brett Howland?
Well, this may be a little too early to ask, but with that last paragraph in the report and last page 3, line 15, after the report of December 15th, is that report of December 15th, 2026, then allow this to come into this committee next session.
Mhm.
So depending on the findings of these workshops, this may or may not come back in 27. It doesn't have to wait until the next sunset to come.
Right.
Right.
So we'll have a report will be delivered to our committee in 9 months or whenever that is. And I think folks would expect to read it and see what the PUC recommends. I mean, it's really up to the PUC to say we did this exhaustive process. We've really thought this through, and we've made X, Y, and Z changes, or we recommend you change the statute in X, Y, or Z way. And so I would assume there would be a lot of interest in, this committee in the next legislation or in the next biennium to take action on that. If not, I mean, yeah, it would be a profound waste of the PUC's time to ask them to do all that work and not to take it.
And it's well before the draft deadline, the due date, so there would be time to draft anything if you were interested.
Okay. Great. All right. Well, let's see.
That's why
Um,
this committee rather than our committee.
all right. Well, I don't think the agenda has changed much. Anyway, just always remember to keep an eye on the agenda because, Alex is constantly updating it, and we'll try to get Mr. Faber in. Okay, we can go off.
Thank you.